Hello, before we get started, let us first introduce ourselves.
My name is Claire Gilroy-Scott and I'm a partner in the employment team at Goodman Derrick.
My name's Emily Kearsey and I'm a solicitor in the employment team at Goodman Derrick.
We've recently presented a number of workshops covering common HR horrors. This is the 5th session in that workshop and it covers dealing with dishevelled Dina whilst dodging the discriminatory dress code. Some of you may recall Heelgate in 2016, which was when a temp, Nicola Thorpe, was required to wear high heels at work, and she was sent home without pay for not complying. This took the media by storm and resulted in a petition calling for a ban on such a requirement, which gained over 150,000 signatures. In January 2017, the Women and Equalities Commission published a report called High Heels and Workplace Dress Codes, which recommended that the government produce guidance on dress codes. The Women and Equalities Commission report concluded that the high heel requirement can be damaging to female workers' health and well-being, with some dress codes making women feel uncomfortable and sexualized. The government responded in April 2017, and their response was that they felt that existing legislation, i.e. the Equality Act 2010, provides sufficient scope for employees who are discriminated against, and Nicola Thorpe eloquently described this as a cop-out.
However, we understand that the government is working closely with ACAS, the HSE and the Equality and Human Rights Commission to produce guidance to improve employers' awareness of this issue and to ensure that women are not held back by outdated attitudes and practices, although this was due to be published in the summer of 2017 and we've seen nothing yet.
They have stated that the guidance will take into account controversial dress code practices relating to high heels and footwear, makeup, manicures, hair, colour, texture, length and style, hosiery, opacity of workwear, skirt length and low-fronted or unbuttoned tops. So we can expect it to be quite detailed when it finally gets published. Now in this session, we're going to consider dress codes in the context of existing legislation and our employee, dishevelled Dina. So, your business requires smart, professional work attire in its dress code. Dina, your receptionist, always comes in looking dishevelled with creased clothing and unbrushed hair. Are you allowed to tell your employees what to wear and how to look? Well, yes, you are. Employers are allowed to set standards of dress and appearance, but these must not discriminate against certain employees. As a receptionist, Dina is likely to be in a client-facing role, so your requirement may be justified. Now, in terms of unbrushed hair and dishevelled appearance, you may want to look at what your dress code says about maintaining a clean and tidy appearance. If you can refer her to provisions in your dress code, this will help to reinforce your position about policy and the standards expected. On the face of it, this looks like a conduct issue, and you may consider commencing disciplinary proceedings if Dina does not tidy up her appearance after informal discussions.
So let's consider your dress code in further detail. Your business requires men to wear a suit and women to wear skirts. Women must also wear makeup and high heels. Dina complains about the different standards of dress that apply to men and women in your workplace. Should you be concerned? Yes, you should not be singling out or discriminating against a particular group of people.
Here, the dress code is different according to gender, and so may amount to sex discrimination. You need to consider whether the restrictions on what men can wear are equivalent. It may be less favourable treatment to require the women to wear skirts if an equivalent level of smartness to the men can be achieved by the women wearing a trouser suit, for example. Thinking about the requirement which relates to makeup and high heels, this may go too far. It should be possible for Dina to maintain appropriate dress and a professional appearance for your business without these additional requirements. So, a dress code policy that makes significantly more demands of female employees than of male colleagues is likely to be unlawful under the Equality Act 2010.
To avoid your dress code being discriminatory, standards should apply to all employees equally. In other words, the dress code should apply equivalent standards, but this does not mean requiring exactly the same for both sexes, for example. So you may require male employees to wear a tie, but this does not mean you have to require female employees to wear ties, provided that they are expected to dress at an equivalent standard of smartness. Make sure you look out for protected groups that might be adversely impacted by your dress code more than others. If so, consider whether your dress code can be justified as a proportionate means of achieving a legitimate aim. Here you would need to consider the aim of the business in setting the code and whether there is a different requirement that can be set that can meet the aim but is not discriminatory.
We're going to look at some possible issues with some specific dress code requirements and possible problem areas, and firstly considering uniforms. Again, here you need to make sure that gender requirements are equivalent. Consider whether all employees should be wired to wear a uniform or just certain roles to minimise potential issues. Think about the fit of the uniform and gender differences in this. For example, it may be harder to justify a buttoned-up uniform for a man, but a low-cut one for women. Tattoos and piercings and jewellery in general are also an issue faced by businesses. Some people look at tattoos as works of art and some do not like them at all. Some employers want to project a corporate image, and tattoos don't fit with a conventional professional image. Some employers may not be quite so corporate, but may still feel that tattoos may be intimidating for their clients. The tattoo question can certainly create issues. ACAS research has found that individuals with visible tattoos and piercings seem to be stereotyped and face stigma in the workplace. Now, having a tattoo, of course, is not of itself a protected characteristic under the Equality Act, but you still need to be careful about certain forms of discrimination. Put simply, if tattoos are acceptable on male employees but not on women employees, then this will be sex discrimination. Think also about age discrimination. Younger people may be more likely to have a visible tattoo and have very different views on this. If you have clear guidelines on your corporate image, and this includes a no visible inking policy, then it may be possible to take disciplinary action against an employee for getting a visible tattoo. As with any disciplinary decision, this does have to be reasonable. Think about the role of the employee and where they work. Are they client-facing or are they in the mailroom? What is the tattoo like? Some employers may not be tolerant of a violent and massive bloodbath scene or rude words on the knuckles, but may consider this very different to a discreet dolphin on the ankle in the style of Samantha Cameron. However, you do need to be careful because you must be consistent in your approach, and some employers simply require tattoos to be covered at work. Another problem area does concern hair, and we've put this specific point as an example because it was the subject of a recent tribunal case. And in this case, the tribunal found that a requirement for short hair isn't discriminatory if it applies a conventional standard of appearance. And the judgment is of note because it pointed out that businesses should beware changes in what is conventional, and so you must consider regularly whether your approach to certain hair requirements and dress codes may become outdated. Jewellery you need to consider as with tattoos. There may be discrimination elements involved in this, and you will also need to consider whether there are health and safety justifications relating to the employee's role.
So moving back to our scenario involving Dina now. Dina's manager isn't happy that Dina has challenged the company dress code and wants to dismiss Dina as Dina has under 2 years' service. What are the issues with this? Well, first, there is a possible sex discrimination claim, which Dina would not need 2 years' service to bring. It is also unlawful under the Equality Act to victimise a person for making a complaint about any alleged discrimination. You'll remember that in response to Heelgate, the government decided that existing protections under the Equality Act were sufficient, i.e. protection from sex discrimination and protection from victimisation when making a complaint.
Finally, we've put a dress code checklist on the slide for you. Firstly, think about whether you need to update your dress code or otherwise introduce a new one. In this regard, you may want to actually consult with employees on dress code requirements and what requirements may be specific and related to their different roles. Consider the impact of certain aspects of your code on groups with protected characteristics under the Equality Act. Consider if exceptions can be applied, for example, in relation to religious jewellery. You will also need to consider health and safety issues relating to particular roles. You'll need to clearly communicate your policy And very importantly, you must be consistent in its application and in relation to any disciplinary action. That's the end of our session today covering the dress codes, but please do link in with us and follow us on Twitter @EmployHeroes. Goodbye.
Goodbye.